felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for evading. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
Now you're under arrest. I'm under arrest? Yep, you got a new charge, both of them. Resisting transport. Resisting? I wasn't resisting.
Pause right there, 10 arrests in just 2 years. That's not just a bad streak. That's a pattern. And in the courtroom, patterns matter. Judges don't just see the current charge, they see the trajectory. So the real question is this just another misunderstanding? Or the moment the system finally says enough? Let me know, does past behavior shape future justice?
Disturbance at a local grocery store. But when officers arrived, the story shifted. How does someone on felony probation for assaulting a pregnant person end up back in court over a charge as vague as interference with public duties? The prosecution claims Zenon went full plank to stop the arrest, while his defense argues the police were the aggressors. With a $5,000 bond on the line and a sealed warrant suddenly surfacing, the stakes couldn't be higher. If you want to understand courtroom psychology and how legal technicalities can change a life, hit subscribe. Let's see how this unfolded from day one.
Oh, you picked up a new case. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case. Specifically, an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, a felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for evading. And now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay.
Pursuant to the, I guess.
I understand.
That we literally had one after the other, like a rung on a step. Yeah. So let's do probable cause. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may.
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd, 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was located.
What?
They saw the couple at the intersection.
They saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon.
Just an open ag assault somewhere else too?
In Fort Bend County, Judge.
My understanding is it's an older case.
At that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, you're putting him in a car and he's like going plank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe, but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're 0.1 mile away from the location. So for what?
Well, okay, I get that. But so we've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him. And I guess at that point says, hey man, I'm going to slap her. So at that point, I mean, that's what we have.
Okay.
Right? Mr. Zenon, there's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation. And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have felony open warrant. And then they find there was something else was there another warrant that you said?
It's the aggravated assault. But Judge, I also would like to point out that they
end up putting him in the car. And at that point, he basically just goes plank like this for them being unable to effectuate an arrest.
And Judge,
I don't think that's an interference.
Now this is where it gets legally interesting. The defense is basically saying, wrong charge, wrong law, and they might have a point. Interference with public duties is one of those broad, flexible charges, almost too flexible. So here's the twist. Is the system stretching the law to fit the situation? Or is this exactly what the law was designed for? Drop your take overreach or fair play.
Things, but
well, certainly they could have taken a whole myriad of. I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on. You know,
but they didn't hit. They didn't. They took the one that I do not believe applies here.
Let's read the code. Okay. Let's see what the code says, because you know there's multiple ways that a charge can that you can charge someone with facts, right? There's multiple ways that can, it's 3815.
That's okay, don't worry.
You're right. It could have been like a resisting, but okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. Now, so I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is.
Okay, so the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute. That's the penal code.
You'll find no argument with me, right? It is pretty vague. Yeah. It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean,
but he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1 miles away.
Felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like, and that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing.
Mm-hmm.
I mean, that's what they were investigating.
And the witnesses all described.
They put him. I guess did they put him under arrest at the time when he said that he was making that threat?
And with being
I mean, did they have the authority to arrest at that time? Right.
So I think it was during their investigation, the defendant admitted to threatening, that he would slap Miss Clark.
And it's at that point they start to put him under arrest.
At that point, they ran him through the NCIC, and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or pushing.
Remember,
That's a resist. That's not interference with public duties.
But it could be that a set of facts can be multiple charges, right? So you could be resisting, but it could also theoretically be interfering with what he's trying to effectuate, with which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. If the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
Well, I mean, it's
Okay, well, I mean, but so
we don't know. I mean,
okay, I'm just saying.
both he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is.
We also don't have the offense report
We
yet,
don't
I
Judge.
don't care. I mean, but I think that there's enough, you know, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
No, I see, I know, but I don't have the video.
I've
I mean, I
shared the
think that-
videos with
remember-
You're right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, you know? Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you're disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go over there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I gotta say.
3 times to search me.
Can I have a moment to look at the video? Here. He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find, you know,
I mean,
if you find a completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, you know. Okay, it looks like they didn't give him a PR bond on this.
Okay, so well,
the bond right now is set at $2,500.
Okay.
Your bond upstairs is set at $5,000. Tell me about that Fort Bend case. Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because it looks like you got on probation in October of this year. When you're on probation, dude, on felony probation, you have a freaking halo over your head. You know, you got to be as good as you can. You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, you know, and I don't know what we need to do to get your attention, man. In life, if you're with a person that brings the worst out in you, then don't be with that person. There's a gajillion and one fish in the sea, but how can a person get you so wrapped around your finger to make you, you know, just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend, Judge, and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set tomorrow, Monday?
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want. Surely. Do you have it?
We have the camera, the body cam.
I just shared.
Okay, so
They just shared it with me.
Yep.
let's roll it to tomorrow. You guys take a look at the video as well. Be prepared, and then we can reconvene tomorrow. For purposes of now, I'll find probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Yeah. Okay. All right, Mrs. Zenon. See you tomorrow.
See you tomorrow. I'm back on Mr. Zenon from yesterday.
Okay. Morgan, I don't know, is this yours? Remember, we're back on Xenon, or?
Probably gonna agree to disagree here. But I would like for you to watch like the 2 minutes of the video that I think.
So, Judge, I also, because you had this question yesterday, I called Fort Bend and they confirmed it. the Fort Bend County aggravated assault with a deadly weapon. It's just sealed, and that's why I didn't pop up.
It's just what?
It's sealed at the moment.
Sealed. Is it a new case? Is it an
It
old
was just
case?
filed in November, Judge.
Wow.
But the offense date was in March.
Okay, so that's what I'm asking. It was the offense date was March of 24.
Yes.
So it was allegedly committed prior to, now, nevertheless, it's still a warrant.
It was,
But how on earth has it never been?
it's because, so they'll unseal it whenever an arrest happens, Judge. The case was filed. He had 2 other charges in this county, even that he caught even after that one.
I'm so confused. You know that there's a, Fort Bend knows that there's a felony warrant, a dangerous felony warrant, and they failed to execute that warrant over and over. He's been on probation. He's been meeting with his.
Stating in here that he's got on 2 years probation for, and then had also a UCW here that he caught after that, and another assault of a pregnant person that he caught here after that, and then another UCW that he caught here after that. So he had just a string of cases, and I mean, the list goes on. But there was just a string of cases that he caught even after that. So I guess they just never, I don't know.
I will tell you the shenanigans from my experience that Fort Bend does. So if they think they're going to TDC, I have seen them let them go to TDC, wait till they even make parole or discharge or finish that sentence, right? And then they're out and they go, oh, now we're going to file you. And then parole goes, oh, now we're going to revoke your parole. Those are the shenanigans that I've seen.
Judge,
And this has been going on for years out there, like prior administration continuing.
But I mean, I guess ultimately at the end of the day, even if that happens, like, let's just say the parole board's going to look and see that it was like extremely old, right? I would have a think. So
So you're gonna extend him for 6 months, but you want a short reset.
very short reset, like
3
maybe
days?
no, like 2 weeks, 3 weeks to make sure that he's paid.
Okay, great. 2 weeks, 3 weeks, that's around
how-
holiday. So can I make it like 4 weeks?
Okay, yeah. Hey, so
Joe,
Joe,
yes,
so what I'd like to do is, I guess, set it every couple weeks to make sure that he's paying into the registry, to make sure that he's paying. First time he doesn't think.
okay, so.
What's that?
So, excuse me, Shatoria said that he can't make payments to the registry. He's gonna have to pay it in full. So he's gonna have to,
What?
Joe has to.
So how do they say that he's got 2,200 then, or 2,100?
So he has 2,200 to pay. He told him I have 2,200 in my bank.
Oh,
So
So.
he's gonna bring that to my office on Monday. And then I'll stick that on my IOTA account.
perfect. Then I'm happy to do it that way.
Okay.
If I so trust you, if you tell me that he's been paying you,
Yes, sir.
I'm happy.
Okay, sir.
So let's do this. Let's set it to Monday. I want to know that he's paid you that, at least that amount.
Okay.
And then we'll set it every, 2 weeks after that to make sure that he's paying you. And it doesn't have to be much. It could be, 50, 75, $100, but I want to know that he's faithfully paying it off. And then, or we can, calculate or have him tell me what is a reasonable amount every 2 weeks.
Yes, sir.
And then
Parents gonna be waived every 2 weeks?
if he pays,
Okay. if he
the
pays.
first time he
I
fails
don't, I'm not gonna read it. It doesn't matter.
is in,
I mean, it doesn't matter. It's on video. It
So
doesn't
I'll
matter.
make a note. Parents required, but
correct.
if he
Right.
pays.
On video, guys. Like, I watched it. I'm not crazy. Like, this, it's on video.
Sorry to keep
Let's
waiting.
talk to Judge about it.
Okay. You're still upset?
Yes, I watched the video and I'm even more upset, Judge.
So Judge, we just want to address some of the questions that defense and you had yesterday. Defense was saying that he felt that interference statute was overbroad. We found case law saying that it's, or vague, that it's unconstitutionally vague. We found case law saying that it's not unconstitutionally vague. It's from DeContal versus State. I've tendered it to defense. Can I approach
Sure,
Judge?
of course. I gotta imagine that if it was unconstitutionally vague, someone would have challenged it and it would have,
Well, maybe I haven't had my case yet.
Okay.
and, I'm happy for you to make new law, always.
Judge, did I hand you DeContal versus State? I did. Just,
The Cantel.
yes.
Yeah. Oh, look, it's out of Court 8 in Harris County.
That's from this case.
Mm-hmm.
So why are you saying that there's no PC in this case?
Is there a PC for something else? Yes. Is there for the interference with public duties? No. I mean, because it's on video, it didn't happen, Judge. Like, so they get calls for an assault, a disturbance, whatever.
You're telling me the fact that they're saying he goes plank in the car while
He doesn't.
being arrested
He
doesn't
does
happen?
not go plank. It's on video, Judge.
Would they say he uses his, I guess he uses
He's in
his,
handcuffs.
The officer has to place his hand on the chest of the defendant to get the defendant to sit back in the car. He also has to grab his legs and push them back into the car. We also watched the video.
We watched the video and we have a timestamp, Judge.
could it be that okay, so I know that a lot of times when they're putting a defendant into the car, they need help, right? They're unable to do it by themselves, or is he actively resisting getting into the car?
He tried exiting the vehicle, Judge. And
No,
that's why they had to push him back into it.
He leans forward. He's yelling at his mom, record, call. The third time they have taken him out. This is 3 times. They put him in the car and they take him out so they can search him. The cop is sitting there going, oh, well, search him again. We can search him 20 times. If you feel you need to search him 20 times, search him 20 times for your safety. The cop doesn't even know what he's charging him with. DA hasn't been caught. The cop's sitting there going, we're getting you for resisting transport. Resisting transport. That is what the cop thinks he's taking of it. DA, Officer Singh, it's a 27-minute video. Okay? At no point is the DA's office called to this point. Okay? That happens after. Fine. For an assault, they can argue. I can argue case law. Ford v. State, specific articulable facts of crime may have occurred. Fine. They are there on an assault. Okay? They didn't take an assault. So then they detain him, right? They find that he has the warrant. So, okay, you're taking him in on the warrant. Fine.
Judge, it's common for officers to conduct an investigation before they call intake. That's not an abnormal thing.
Yeah, I mean, that's neither here nor there, but the question is he impeding the arrest or the function of arrest? Because I guess that you guys are basing the interference on the fact that he's not allowing him that, what's his name again?
Xenon, Your Honor.
Mr. Xenon is not allowing the officer to arrest him by putting him in the car.
Respectfully, Judge, the officer doesn't even have to be arresting him. They just have to be looking into any legitimate matter. And then he's interfering with that. And I will say, if he'd already been in the car 3 times, like defense pointed out, I would think he wouldn't need help getting in. So to us, it appears as though he's trying to push out. The officer has to put his hand on his chest to push him back into the car and then take his legs and place them into the car.
He was cooperative the whole time. He's on his mom. If anyone's aggressive, it's the cop from the beginning.
Judge,
And I ask at the court's discretion, watch the video. You only need to watch like 2 minutes, the 13 to 15 minute mark, Your Honor. I mean, that's all you really need to watch on this.
Judge,
Watch or no?
We can watch the video, Judge.
Cue it up. Let's watch. Can you put it on the screen somehow so we can all watch?
we can just go to the back and watch it. Do you want to hook it up?
No,
I don't, because he has issues hooking his computer up to the technology. It's this one.
Judge, did you want to watch the whole video, or did you
No,
want to?
just the relevant portion. I don't need to see the whole thing. No, just that part that's relevant. You know, I guess if you want to just put it right there and just turn it around.
Yeah, just put
Just
it
right
up
there on the table. Yeah, right there. And set it.
I'm just turning the volume up, Judge, as well.
He talking about don't let him pull up. They talking about I got a warrant out for Fort Bend County for assault. Look, he pushing me. Mama, record it. Mama, look, record him. Now you're under arrest. I'm under arrest. Yep, you got a new charge, Bubba. Resisting transport. Resisting? I wasn't resisting. You just resisted transport. Yep.
What the hell is that?
Now you got a new charge. Yep.
And there it is, the moment everything falls apart. After all that build-up, all that legal debate, the video doesn't match the narrative. This is why evidence beats argument every single time in court. One clip can destroy an entire case. So now I've got to ask you, was this a failed arrest or a failed charge?
Yeah, look, yeah, I mean, you're not going to hurt our feelings. You need to do what you need to do. Perhaps it was the wrong one, but yeah, was it resisting?
No.
My name is Bennett and I ain't in it, but no PC.
Thank you.
Hey,
Just real quick.
I changed it. Also, yeah.
Do you want me to do anything? Like, I don't. Well, I wanted to see, are they filing a dismissal or no?
You didn't ask them. Ultimately, they don't have to. Right? They can take it for granted.
I stay on it. That's why I'm just trying to figure that out.
As far as us, I lose jurisdiction, right? So there's nothing that I can do.
Right, but my question is, but it's not gonna. It doesn't matter. But if Fort Bend's gonna pick him up, right?
Ben
Has 10 days now, right?
No. Let me see. Hold on. So he's on probation for the case of
Motion's been filed up there.
Let's see. Morgan, do you know what has happened with Xenon upstairs? Have they filed a motion?
They haven't filed it yet. I talked to the felony prosecutor. He said their court's been in trial all week, so they haven't got the chance. They haven't really looked at it. I think he said he was planning on filing a motion, which I
He got arrested on.
They're all dismissing us right now.
So he got arrested on the 3rd. Is that right?
For this case,
Correct. Because once we get him, if there's a hold out of Fort Bend County, they have 10 days from the date of the arrest. You come get him. If they don't come get him, I give a PR bond on the 11th day. Unless I know, and Fort Bend has told me that they're going to, and they've told me they're going to come pick him up. That's the only time I'll hold him an extra day.
So does he need to be appointed a fugitive attorney?
No.
It's low.
It's only for
Texas
out-of-state cases. So look, there is a hold out of Fort Bend County. So he's basically bond denied on that case. He cannot get out for any reason because of
that, right? This isn't holding him. There's no regard.
On the 11th day, if they've not made travel arrangements to come get him, I'm going to release him and I'll give him a PR bond. So your guys up there have basically another 7 days before.
Yes. And so if they refile it, am I still attached? Is my other question. Do you even know the answer to that?
I think that your duty now ends as the lawyer.
Okay.
Unless, are you planning on dismissing it or are you going to keep it?
They say they're going to refile as a resist.
Okay. We still need to know though what you want to do with this case. Like if you're going to keep it, because if you do, I have to reset it for some period of time.
typically does.
Yeah, check on that because that's gonna depend my next question.
Regardless, he's in there at least for another week.
Okay, well, real quick, because if it's going to remain attached, then I'm going to ask for speedy trial.
Yeah, but remember, I got to give them.
I'm still attached.
But I got to give them at least 30 days.
Then I'm just going to do the whole PC thing with you again, depending on what the refile is. See what I'm saying? So if they're going to refile a resisting, if it's
it sounded you agreed to the resisting too. So
I can agree to the resisting.
No, I'm kidding. I don't know. Let's see what they say.
I mean, it's not a resisting either.
I don't know, but prior to that, was there with the resisting? The resisting is not there in the car. The resisting was beforehand. I don't know. I mean, as far as
I show you that as well if I have that.
Okay, it's never going to go away.
Just dismiss it for now, just subject to refile.
Okay, cool. Thanks. All right, thank you.
The judge made the call, no probable cause for the interference charge. Mr. Zenon walked away from that specific arrest, but his battle with the system is far from over. But here's the question. Do you think the plank move should be a crime, or was the officer just looking for a reason to arrest him? Comment below, Team Zenon or Team Officer. If this case got you thinking, hit like. Share this with anyone who loves courtroom drama.